Friends, today we shall discuss the related provisions of legal aid under the Indian laws. To start with, the idea of giving legal aid arises due to the reality that inequality persists among the people of India, where only the rich are today able to file their cases by engaging expert lawyers, while the poor are left undefended due to their inability to engage a lawyer. It's a reality that only the wealthy class resorts to courts of law. The traditional legal system closes its door to the poor. It is only after the year 1976 that the provision of legal aid finds its place enacted in the Constitution of India in Article 39, capital A. Under that article, the states are to secure and provide free legal aid by suitable legislations or schemes, or in other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or any other disabilities. After the provision of the free legal aid incorporated in the Constitution, many states in India responded to the directive and have made rules and schemes for providing legal aid to the poor sections of the citizens, and the present position of the legislative provision relating to legal aid is the Legal Services Authority Act 1987. However, it will not be correct to say that Article 39A is the first step for providing legal aid to the citizens. Some laws in India incorporated provisions which are related to providing legal aid some way or the other. Therefore, it is imperative to review the legal provisions that are enacted in the different legislations which are in force in India in different stages, that is, the laws before the commencement of the Constitution of India, the laws after coming into force of the Constitution, the development of the laws relating to legal aid after coming into force of the Constitution 42nd Amendment Act 1976, and the various developments of the provisions of the legal aid after passing of the Legal Services Authorities Act 1987. The Code of Civil Procedure 1908, which is popularly known as CPC, was enacted to consolidate and amend the laws relating to the procedure of the courts of civil judicature, which extends to whole of India except the state of Jammu and Kashmir, the state of Nagaland, and the tribal areas. Order 33 of the code is the provision of institution of the suits by the indigent persons. A person is said to be indigent if he is not possessed of sufficient means to enable him to pay the fees prescribed by the law for the plaintiff in such suit in a civil court. The provision for institution of suit by an indigent person is laid down in detail under Order 33, and this is a provision enacted for providing relief to the indigent person by allowing them to file suits without paying the required court fee for institution of a suit. This provision is related to provide legal aid to indigent persons to enable them to file suits. To mention another law under Section 21 of the Arbitration Act 1940, a provision akin to Lok Adalat that was found enacted, and it is provided that where in any suit all the parties interested agree that any matter in difference between them in the suit shall be referred to arbitration, they may at any time before the judgment is pronounced apply in writing to the court for an order of reference. The section says that if the parties agree to refer the difference to arbitration, the court can do so, and the matter may end up in settlement without following the expensive and time-consuming legal proceedings. These are some of the legal provisions which related to giving legal aid. The Constitution of India came into force since the year 1950, and India became a sovereign democratic republic. It aims to secure the citizens, amongst others, social and economic justice. Legal aid to the needy is an instrument of social justice, and social justice implies that each citizen in relation to the society must be treated equally and justly, irrespective of his or her caste, creed, descent, race, religion, sex, wealth, and status. The Constitution of India, as originally enacted, does not contain provision for legal aid. Reviewing the laws passed after the commencement of the Constitution, one will find that the rules framed by the Bar Council of India under the Advocates Act 1961, that is Rule 41 of the Chapter 2 of the rules, which provides that every advocate in their practice of the profession of law bear in mind that anyone genuinely in need of lawyer is entitled to legal assistance, even though he cannot pay for it fully or adequately, and that within the advocate's economic condition, free legal assistance to the indigent and oppressed is one of the highest obligations an advocate owes to the society. The Bar Council of India has laid down this particular rule for assisting any indigent person who approaches an advocate in his individual capacity. This rule has particularly been made by the Bar Council of India, keeping in view that legal profession is a noble profession. Referring to the Code of Criminal Procedure of 1973, popularly known as CRPC, that came into force by repealing the Code of Criminal Procedure 1898. The new code incorporated the provision of legal aid to the accused at the state expense in certain trials. Under Section 304 of the Code, it is provided that where in a trial before the Court of Session, the accused is not represented by a pleader, the court shall assign a pleader for his defense at the expense of the state. It is further provided that the state government may, by notification, direct that as from such date as may be specified in the notification, the provision of giving legal aid shall apply in relation to any class of the trials before the other courts in the state as they apply in relation to any class of the trials before the Court of Session. The High Court may, with the approval of the state government, make rules providing for the mode of selecting defense pleaders and the facilities to be allowed to such pleaders by the court. The courts in India held in a series of cases that right to legal aid is a fundamental right of an accused person standing in trial. To mention such a case is M.I.'s Hoskot versus State of Maharashtra, AIR 1978, Supreme Court, page number 1548. It has been the view of the court in Matlub versus Delhi Administration, 1997, volume number 3, Crimes, page number 989, that entitlement of free legal aid is not dependent on the accused making an application to that effect, and the court is obliged to inform the accused of his right to obtain free legal aid. Coming into force of the 42nd Amendment in the year 1976, the provision of legal aid is incorporated in the Constitution in Article 39, capital A. It is a directive of the Constitution to the states to secure legal aid to the citizens who are hit by economic or other disabilities. Various states in India responded to the directive and framed legal aid schemes applicable to their respective states. The state of Manipur is also one of the states which responded promptly by framing a rule known as Manipur Legal Aid to Poor Rules 1976. The provision was not elaborate and could not come to the rescue of all the poor citizens, as it was not made popular by the wide publication. Thereafter, the state of Manipur had framed the Manipur Legal Aid and Advice Rules 1982, replacing the old one. The rule came into force since 1st of October 1983, and the rule was framed with a view to provide for equal justice on the basis of equality of opportunity and to provide free legal aid to those whose opportunities for securing justice could be denied by reason of economic and other disabilities. The rules contain 64 rules arranged into 8 chapters. A two-tier system of authorities is provided. That is, at the apex, there is the Manipur Legal Aid and Advice Board. At the district level, there are district committees for legal aid and advice. A person who is eligible for legal aid and advice may make an application in duplicate in a prescribed form addressed to the secretary to the board or to the district committee. The board may allow or reject wholly or partly every application made to it. There existed another contemporary legal aid rules which was framed by the Government of Manipur Secretariat Labour Department, called the Manipur Legal Aid to Labour Rules 1987. The objective of making such a rule was that workmen employed in industrial establishment are terminated or discharged or dismissed from service on a prima facie untenable grounds, or where it becomes necessary on their part to file claims for recovery of sums due, etc., but are unable to seek legal redress of their grievances from the court, industrial tribunal, labour courts, etc., by reason of economic or other disability of the aggrieved workman and the trade union of which he is a member. Another dimension of the problem is that when reference was made to, or when awards are given by labour courts or industrial tribunal, instances have occurred where the employers have gone to the High Court or Supreme Court by the way of writs or appeals, resulting into protracted litigation. Therefore, the government thought it proper that the workers and their unions should be given legal assistance by providing them with the services of advocates. Keeping these objectives, the government has made the Manipur Legal Aid to Labour Rules 1987. A workman or a trade union is eligible for the legal aid if both the workman and the trade union of which the workmen are not having sufficient means to engage counsel to pursue their case. The labour officer is the authority to decide as to whether a workman or trade union has sufficient means or not. Legal aid in the sense prescribed by the rules means the assistance given by the government to the workman or trade union by providing services of advocates at government cost or by paying requisite fees to an advocate who is appointed by the workman or by the trade union. A workman or trade union of which he is a member shall apply to the Labour Commissioner for giving legal aid. The Labour Commissioner shall cause an inquiry to be made to satisfy as to the eligibility and fitness to grant legal aid. If the Labour Commissioner is satisfied to the eligibility and fitness that the applicant is eligible to receive legal aid, it shall pass an order allowing the application for the legal aid. The government shall allot fund each year for the purpose of legal aid under these rules, which shall be provided in the budget for the labour welfare sector. The Legal Services Authorities Act was passed in 1987 with the objective to constitute legal service authorities to provide free and competent legal service to the weaker sections of the society, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities, and to organize lok adalats to secure that operation of the legal system promotes justice on the basis of equal opportunity. Even though the Act was passed in the year 1987, it came into force only since the 9th of November 1995, and the National Legal Services Authority was created. Like other states of India, the state of Manipur had constituted the Manipur Legal Services Authority in the year 1998. The Act has 30 sections arranged into 7 chapters. Legal services include the rendering of any service in the conduct of any case or other legal proceedings before any court or other authority or tribunal, and giving of legal service in any legal matter. These services are provided by way of making available of advocates at state expense, paying court fees on behalf of eligible persons, bearing expenses regarding preparation of documents, paying expenses for summoning of witnesses, and paying other incidental expenses connected with the litigation. And under the Act, the person eligible to receive free legal service are a member of scheduled caste or scheduled tribe, a victim of trafficking in human beings or beggar profession as indicated in Article 23 of the Constitution of India, a woman or a child, a mentally ill or otherwise a disabled person, a victim of mass disaster, ethnic violence and caste atrocities, flood, drought, earthquake or industrial disaster, an industrial workman, a person in custody including protective home, juvenile home, psychiatric hospital, psychiatric nursing home, a person having annual income not exceeding rupees 50,000. An eligible person may apply to the member secretary of the Legal Services Committee or chairman or secretary of the District Legal Services Authority, stating the brief facts of the case and copies of relevant documents, if any, with an affidavit. Some of the other important functions of the State Legal Services Authority are to organize lok adalat cases, that is, pre-litigation cases, to organize legal awareness or legal literacy programs throughout the state on varied subjects in collaboration with local clubs, NGOs, in junction with the district legal services authorities, to establish legal aid clinics to spread legal awareness in the far-flung areas. The Legal Services Authorities Act 1987 was amended in the year 2002, which brought in a provision for setting up permanent lok adalat The permanent Lok Adalat can be approached by any party to a dispute involving public utility services which have been defined in the Act, such as transport services, telegraph or telephone services, insurance services, etc. Any civil dispute with a public utility service and where the value of the property does not exceed rupees 1 million, or any criminal dispute which does not involve an offence not compoundable under any law, can be taken up in the permanent Lok Adalat. An important feature of the amendment is that after an application made before the permanent Lok Adalat, no party to that application can invoke jurisdiction of any court in the same dispute. Such dispute involving public utility service shall be attempted to be settled by the permanent Lok Adalat by way of conciliation, and in doing so, the Adalat shall be guided by the principles of natural justice, objectivity, fair play and equity, not being bound by any civil procedure, court or law of evidence. Every award of the Lok Adalat shall be deemed to be a decree of civil court and is finally binding on the parties to the dispute, and no appeal lies from the award of the Adalat. The Universal Declaration of Human Rights 1948 and the International Covenant on Civil and Political Rights declare norms that everyone has the right to an effective remedy by a competent national tribunal for the acts violating fundamental rights guaranteed by the Constitution or law. The right to defend oneself, legal assistance to him, to his chosen counsel, to be informed of that right, the duty of the state to assign legal assistance to him without payment of fee when he is indigent are the provisions clearly spelled out. The Government of India, in order to give effect to these human rights, constituted a committee under the chairmanship of Justice V.R. Krishna Iyer. The judge of the Supreme Court of India, to consider the question of seeking and giving of legal aid and advice that could be made available to the weaker sections of the community and the persons of limited means in general, and socially and educationally backward classes in particular. The said committee submitted its report in 1974. The report is known as Processual Justice to the People and dealt extensively with the need of legal aid and advice to the poor and backward classes. It recommended the introduction of concept of legal aid in the Constitution of India. Article 39 capital A was incorporated in giving effect to the recommendation. The report of the expert committee chaired by Mr. Justice Krishna Iyer was published as a book called Justice Krishna Iyer's Processual Justice to the Poor.